So sorry, we were all late in sitting in court because, today we dedicated the new creche. There's such a large number of young men and women lawyers. The earlier creche was about 200 square meters, which could accommodate about 30 children. Now we have 450 square meter creche, which accommodates close to 100 children, for our staff and for the members of the bar.
And the children do come.
Oh, it's packed. In fact, we have constantly requests. Now my child is turned 6. Can I have an extension for 4 months because before the child? So for those of you members of the bar, you may not have children, or as in the case of the solicitor, you have a grandchild, but please do go and see the creche. It's in the additional buildings, administrative buildings complex. It's a beautiful creche facility.
They are so beautiful that you might want to yourself stay there.
I'm waiting for the moment when some honorable judge says that you are too childish in your arguments. That makes me eligible to go there. But, my lord, we can do one thing, my lord. We can, my lord, I will not use, the donate is not the correct word. We can contribute by giving toys or something, my lord.
We have in that creche, we have a play area for the children. The entire area is lined up with cushions so the child shouldn't, it's child friendly. Bathrooms have been redesigned for little children, including for changing rooms for changing babies' nappies. Then we have, apart from a play area, a dining area for the children, a feeding area for young mothers where you can feed your child in privacy. And there's a sleeping area for the children also. So the child there's a completely quiet area where children can sleep during the day, so on and so forth. So especially for, I always say it's not just a mother's thing, it's a father's thing as well. So all young lawyers would like to go and see it. Please go and see it during the course of the day.
Will make it a point
to go and we'll be happy to see the. And of course, we also unveiled today the new branch of the Bank of Maharashtra in the administrative buildings complex. So for the benefit of the lawyers, and it's a high-tech branch where we have automated lockers, all the other facilities, including wealth management, so on and so forth. So the prosperity of the lawyers should be reflected in equal financial services to them.
Yes, sir.
Some of the financial services that were explained by the branch manager and the chairman, I thought would mostly be intended for the professionals in the field, not for the judges.
Not till the honorable judges retire, my lord. Lord, but lockers for lawyers for professional services may not be a good idea. Lord, I'm obliged, Lord. Lord, my lord.
Yes.
Just highlight, my lord, what I would be, my lord, assisting your lordship with. Lord, the first principle.
Mr. Solicitor, we'll of course go by a very heartening and fair statement yesterday that you will not take as much time as was reflected in the statement. We have seen your written submission, which are comprehensive, actually.
I stand by that. From there also, whatever my learned friends have already drawn your lordship's attention to, I'll skip. And my lord, my broad roadmap, my lord, for assisting your lordship is this. Lord, arbitration has necessarily its roots in the contract, and contract by necessary definition is an act of volition.
Contract is a
act of volition by definition.
I know, but equally, we know the other flip side. Say somebody who wants to be a contractor with railways does not really have a negotiating capacity. Either you accept the contract.
I have an answer to that. My submission.
It is an act of volition. So you agreed to this arbitration clause. How can you complain of the arbitration clause?
No.
At the same time, we must also we see both the sides.
Certainly.
But there's not that element of volition. If I want to sort of supply bitumen for the construction of a road, and I'm a small petty contractor, I have no negotiating power.
Standard form contracts, that
I usually clause 64, I leave clause 64, or I leave the contract.
Correct. Your lordships, my lord, as custodian of fundamental rights, would look into it. But I'm just starting my arguments. my lord, your lordships at the end of it may perhaps be satisfied that the system which I have envisaged within the framework of law
Is a
may,
good system.
my lord, meet with your lordship's concerns and, my lord, may achieve the object for which the act is enacted.
All right. So that first
Lord,
point is.
second, Lord, party autonomy is ingrained in the entire architecture of the act.
Yes,
No, my lord, and,
that's your argument being transcribed.
yeah, yes, in the entire architecture of the act, my lord, that's the submission. Third, third, Lord, unwittingly the respondents, Lord, who began the arguments, Lord, were trying to find out whether there is any permissive provision which provides for a neutral panel. Lord, my respectful submission is the question is wrong and therefore we are not getting an answer. The question should be whether there is any restriction which prohibits the panel which I am going to analyze. My lord, the panel also must satisfy your lordship's conscience.
Just for a little clarification, you say the panel which I'm going to suggest, you would be making that statement on behalf of the Union of India as an entity or how? Because
Yes, yes, but I'm not suggesting on my own.
Right.
I own, my lord, what I'm arguing on behalf of Union Railway, Central Railway Organization is the petitioner. So for petitioner also, my lord, that's not, my lord, the point. Lord, it is to be found in the act itself.
oh, then there is. Yes.
Lord, why this exercise is necessary? Because, my lord, I'm not going individually to Perkins or any other judgment leading to Tatia, my lord. That's not relevant because your lordships are in a 5-judge combination. We address your lordships on principles and my lords would examine on principles. But somewhere down the line, my lord, there is a concept that this kind of panel does not give them the choice and therefore panel is impermissible. This is my paraphrasing. The wordings of the judgment may be wrong, may be different, but this is, my lord, broadly, few judgments have taken them. And that is, my lord, a valid concern that they must also have a choice. But please, my lord, kindly bear in mind, this is, my lord, an alternative dispute redressal mechanism. The parties contract that instead of going into the normal conventional litigation, we would customize our dispute resolution mechanism. The objection necessarily presupposes that the panel is controlled by one party and therefore we do not have much of a choice when there is a provision which misses the distinction between Which misses the distinction between a panel being maintained and panel being controlled. I can maintain a panel of neutral and impartial arbitrators without in any way controlling it.
Panel maintained and
Controlled. That is the distinction. They argue that this panel is controlled by you. My respectful submission is that the panel is maintained by me, not controlled by me. Your lordships are aware, my lord, depending upon the nature of activity of that particular contract, there can be, my lord, a panel involving honorable judges, it can be structural engineers, it can be architects, it can be civil engineers, it can be chartered accountants, everyone.
You're right, actually, Solicitor, because their argument was that my objection, according to them, their objection is that this panel is controlled by the authority, by railways or by bail or whoever else.
Lord,
But then you'll have to, in your option, which you explore before us, you will have to tell us how would you ensure that that control element is
exactly. Lord, I'm grateful for that. Lord, that is where the judgment in DMRC, Lord, I said DMRC because Voestalpine, Lord, just for easy pronunciation, I said DMRC. Lord, what they say that your panel should be broad-based panel, having no having, my lord, people from various facets of life, depending upon the organization which is making the panel. And that judgment is fortunately not disputed by anyone. That judgment says that panel per se, if it is contractually so provided, is not something impermissible. But you cannot have a panel of, say, 20 people, choose any one of them.
Except that Mr. Kaul, in the latter part of his submission yesterday, said that, look, while I accept the broad Voestalpine principle, this part, which says that so long as you constitute a broad-based panel, that is valid. He says that he has assailed in his submission, because I just looked at my notes.
Otherwise, my lord, kindly see the flip side of the argument.
Because, to paraphrase what Mr. Kaul argued, he says Voestalpine recognizes the principle of a broad-based panel. And the submission is that the objection is that the panel cannot be unilateral. To the extent that Voestalpine allows it, he says Voestalpine needs to be modified or reconsidered. That was squarely placed.
To that extent, my lord, there is a divergence, my lord. They are not accepting.
finding me to the panel.
Lord, the other side has argued one extreme, that whatever the one side does is unilateral and therefore necessarily not impartial or would otherwise be objected to. But the flip side is, if that is not accepted, then you are free to choose your arbitrator, which may have some issues of impartiality and neutrality. And when I say impartiality and neutrality, I also include integrity.
But then, that will apply to you also. That's the point.
Correct. Therefore, I have an answer.
What Anirudh argued yesterday, in the latter part of the submission, was that you may have a situation where the arbitrator who is on your panel perfectly fulfills the Schedule 7 requirements. And since you are approaching it in a very balanced way, we are really putting it to you.
Yes,
you can find a solution for us as SG. So Anirudh argued that, look, the arbitrator on your panel, nobody will breach the 7th schedule requirement. But apart from the objection that this is a unilateral panel, he said, there must be one more thing. Take a concrete case, he says, where that person has already done one arbitration in a period of 3 years. You constitute a panel so as to appoint only those people who have already ruled
Incentive,
that interpretation of, say, clause 36 of the general conditions of contract.
Correct.
Second, he says after the lapse of that 3-year time period, when the cooling off period is over, the organization can look at what is the track record of this arbitrator. Has that arbitrator been particularly helpful from an institutional perspective for us? We're not saying it is fraudulent on your part to do that, but this is natural. This is natural on the part of any organization. So therefore, the objection that, this may not necessarily result, a broad-based panel may not be an adequate formulation, because within that broad-based panel, there may be some problems which will never come to light otherwise. That's it. How do we
Yes.
answer that in the scheme which you are creating for us?
The way, my lord,
Just Rishikesh Roy said, does it hit the equality principle then?
Lord, I'll come to that. My lord, there is
Later I can-
some confusion. My lord, equality principle has a different connotation under the act. My lord, I take your lordships to
You
some
can go in your own way.
a scheme
So,
provision,
last
scheme of
point
the.
that I've
But my lord,
noted
let
is
me put it this.
Wasserpine holds that the panel should be broad-based, having people from various facets of life.
Yeah, yes. My lord, ultimately, I'll say this last, but
And you're
I'll
supporting that part of Wasserpine, right? That's
That-
what, you're supporting that Wasserpine principle, I take it, that the panel should be broad-based?
yes. My lord, adding something into it.
All right.
Because ultimately, as a government, we are also interested in ensuring that the arbitration as an alternative dispute mechanism grows, it furthers, and whatever are the hindrances or whatever are, my lord, what is preventing people from going into arbitration, especially the government agencies, is taken care of, and therefore I'm adding something.
Absolutely. And one perspective which government must also bear in mind is that if we are now today in an economy where we feel that private investment is crucial for the growth of the
Correct,
nation.
my lord. Government is
The
concerned.
nation. Therefore, from a broader national perspective of the government, it may be the interest of one PSU to rig the arbitration. We're not saying that they do it, but I'm just telling you. But from the wider perspective of the government as a nation state, there is a vital public interest or national interest in ensuring that the process of arbitration is fair.
Absolutely.
One element in that is, of course, huge public revenues are involved. If you get an award for 20,000 crores, it's part of the public revenues pay for it. Equally, government as a nation, representing the nation, has to be concerned of the fact that you must have the faith of the private sector in the arbitration process.
Who will invest.
To invest.
Yes.
And there's not just foreign investors, but domestic investors also.
Correct.
Right? So there is, in that sense, there's a governmental interest in both sides.
And public interest, that means public interest.
Governmental interest is not here only in getting favorable outcomes in the arbitration. That may be the interest of, say, ONGC, BAIL,
No, I
particular
understand.
contract.
No, I'm not taking it
Government's
from that.
interest is on a much broader perspective, which
I
we
have
must bear in
not examined this from that myopic point of view, but I'll be very candid with your lordships, my lord, while being careful about the expressions I use. My lord, sometimes the system which we are following, that there is one arbitrator appointed by the government, PSU, or any other, my lord, a public sector body, and a private body. Sometimes, my lord, because of lack of neutrality, which includes integrity, we do not have a level playing field. I'll use my expressions, my lord, very cautiously, my lord, and I know, my lord, I am able to convey, my lord, what I am. Therefore, my lord, my panel, my lord, which I am improving upon, my lord, DMRC judgment is, A, they have a right to say that this is a tailor-made panel. To defeat them is a valid concern. To obviate that,
Can you just say that again, Solicitor?
Lord, the panel should not only be broad-based, but these are the criteria which your lordships may consider while improving upon what DMRC has said. I'm sorry, I forget the first name, therefore I'm, for my easy reference, using it at DMRC judgment.
Say should have additional safeguards
Yes, my lord.
over and above voestalpine.
Yes, Lord.
Like,
Lord, first, the preparation of the panel must be open to all and transparent.
Just to, panel preparation should be transparent, not vis-a-vis a particular case, but generally.
Generally, yes. And when I say open and transparent, I mean, I will give an example, my lord, of say Ministry of Urban Development and Urban Housing. They issue an advertisement that we are preparing a panel of engineers. These are the qualifying criteria. These are eligibility criteria. You must ensure that there are no vigilance angles, because engineers are always, my lord, having some vigilance angles. Sometimes you are not having any vigilance angles, just to ensure the integrity of the individual, etc., etc.
this is very important. So first was preparation of panel must be open to all and transparent. Two, I've said it two, the process. And then in two, I've said process. A, issuance of an advertisement, laying down the parameters for
Anyone can apply for being included in the panel.
panel. Issuance of an advertisement, laying down parameters, whether Roy said, laying down parameters for empanelment.
Yes, my lord. And anyone can apply who is qualified as per the panel. So that, my lord, we can decide, at least from our internal inquiries, etc., about the reputation, about the integrity issues. But this is not, my lord, very difficult to gather. So there is some, my lord, check. Otherwise, there is no check. Lord, but the expressions which are used in, my lord, in the arbitration field, I'll not use those expressions.
Again, just don't answer it immediately, because you're going in a systematic way. Suppose 15 years down the line, Mr. Call says, well, I want to now be an arbitrator. Would you expect him to apply for empanelment? How do you deal with that issue?
That
The best will never apply for empanelment.
my lord, in international field, my lord, even eminent people, as eminent as Mr. Call, my lord, may send the details. I'll apply, my lord, may perhaps not be a correct word, but may send the details. Somebody else can send his details on his behalf.
We have never had.
Lord, an option for invitation can also be, my lord, kept open. There is no, Lord, we are not trying to make a tailor-made panel.
See, I'll tell you, you're right. Calling for applications promotes transparency. All right. But I'll tell you a little bit of my experience, because I've been now chairing the selection committees for appointing chairs of tribunals, national tribunals in India. Right, whether it's the National Green Tribunal, the National Company Law Appellate Tribunal. So many of my colleagues sit on these tribunals.
Correct.
The moment we circulate an advertisement for application, best judges don't apply. They say, if I'm good enough, take me. Why should I subject to myself to more eminent professional? They'll not apply. Now, therefore, what we have, your government has found a solution to it. The government calls it a search cum selection committee. So very often when I say sit with the Secretary Ministry of Finance, Secretary Department of Personnel and Training, these are usually the secretaries who come, right? Or Secretary Consumer Affairs.
Or Justice, or whichever is the.
Right. They normally say that, sir, we will open it out for advertisement, but it's a search cum selection committee. So they always tell us that you have the overriding power to also give us names of people who will not otherwise apply. Now, that assumes a degree of good faith, right? So if I'm sitting there, there's a degree of good faith that the Chief Justice of India is sitting on the panel. Or see, I very often depute my colleagues, that Justice Rishikesh Roy is sitting there. There'd be a feeling on the part of the secretaries that if Brother Roy is recommending somebody, Brother Narasimha recommends somebody, there are bound to be good people above board. And thereafter, of course, the IB process and everything is, their track records are verified by the Intelligence Bureau. But this is okay, you know, when you have people who are at this level. What happens, suppose the railways are constituting a panel? Who will take that decision on whom to induct in the
I'll
panel?
answer that question.
It will be ultimately a general manager in railways. At what level will that decision be made? Will it be the chairman of the railway board?
But that is one of the highest
So,
decision.
you know, the devil lies in the fine print.
That perhaps the minute nitty-gritties can be gone into only by the legislature. But
Well,
I
in
have
fact, just 1 second, I might forget it. We were just in our
then, yeah,
discussion.
please, please,
Only because it might slip our mind. Point from Brother Rishikesh Roy, will this be a panel? It should not be a panel then confined only to one undertaking. For instance, is it possible for the union government to say that, well, we are preparing a panel cross undertakings because we have large number of PSUs, Navratnas, non-Navratnas. This is a panel, we will do the exercise at the level of what, maybe the level of the cabinet secretary to the government of India, because you are dealing with thousands of crores, if not lakhs of crores, that we will do this exercise across our public sector undertakings, and we will review the panels on a yearly basis. You can have, suppose there's a secretariat where you are reviewing the track record, any adverse complaints about the conduct of an arbitrator, so on and so forth. So we have to also factor in that arbitration has got sometimes a very bad name. We have wonderful arbitrators. We have some amazing arbitrators, but we also have both ends of the spectrum today.
That's the concern of, second is the
So
concern of.
would you be therefore contemplating a situation where Government of India prepares a panel for all undertakings of the Government of India, which will include your coal fields, you will include your railways, or will it operate at a ministerial level? So Ministry of Coal will have a panel, Ministry of Finance will have a panel, Ministry of whatever, Corporate Affairs will have a panel. That will be again unworkable.
Yes, sir. My lord, my answer is, my lord, very clear. My personal answer is yes. I'll take instructions. I don't see any problem. Why? My lord, I'm confident that I may not have any problem. Your lordships are aware, and my lords, all of you lordships must have come across. There are certain things which are applicable to everyone. For example, public procurement. The government of India makes the policy which is binding on all public sector undertakings. That this is how you will have to procure goods, services, etc.
Just see how complex it's going to become. And that's something which Justice Pardiwala mentioned just a minute ago. Take the case of Food Corporation of India. Take the case of Western Coalfields. Food Corporation of India has a pan-India presence. You have contracts for transportation, contracts for godowns, for which you are awarding tenders which have arbitration clauses. Now, if we were to contemplate a situation where the government of India were to do this exercise, the task would be gigantic because you will have contracts from 10 crores to 10,000 crores
Sir, and 10 lakhs?
and 10 lakhs.
10 lakhs also. My lord,
Value based also.
value based and the eligibility based. For example, for some we need only engineers. For some, where there are questions of law, we need judicial mind.
Are we walking into a minefield?
We are,
We
slowly and steadily, basically, writ being the writ bar, we are effacing the distinction between public law and private law. Today's discussions and much of yesterday's distinctions seem to be how to bring in transparency in public dealings. That is what public law does. Administrative law is what it does. But this is in the realm of a private
Yeah.
remedy.
contractual.
Talking about private remedies where the choices are with the contracting parties
Correct.
to decide how our remedy should work out.
Correct.
It's a different matter. I mean, in a contract where there is a conflict of interest, contractual principles will resolve that conflict of interest. But superimposing public law perspectives, as if these are public tenders, so where is the transparency? Where is the level playing field? Those principles, knowing very well, England has kept it aside completely when it came to private and judicial, private composition of judicial remedies.
Lord,
And we are not
As well as today, I mean,
Lord, why this is
in what
required?
we apply today, this reference is not only confined to PSUs. There'll be also large,
Private parties, yes, of
right?
course.
There'll be large corporations also.
Lord, Reliance versus JSW, hypothetical. There is
Any of our large companies.
Larsen and Tobro versus so and so.
Now, how would this whole concept of having one panel work in the private sector? What we
It cannot
what
work.
Brother
It cannot
Natsma
work.
says, to just bring a synthesis, what Brother Natsma's point is that
My
look,
lords are right.
we are
Absolutely.
essentially in the realm of private law. So,
We are
in our effort to protect the revenues of the government, we must lay down a principle which applies across the board
Lord,
to all contracting parties.
Lord, let me answer that. Let me answer that
remedies are
squarely.
private.
Your lordships are
There is a slight distinction between mediation and arbitration to the extent that it automatically becomes a decree enforceable. The meaning of decree being enforceable is that the state's power is behind a decree, behind an award.
sovereign.
To that extent, it becomes public. But with respect to all other matters, choices of remedies,
Absolutely.
choices of
No,
and court keeps superimposing. Forget about that.
And my
Legislation
answer
is
is
another matter.
squarely, my lord, my answer is this. We are required to go into the question because the question in one line which has arisen is whether in a private field of a contractual relationship, there is a permissibility of a clause which permits panel to be prepared by one party. It is always open for others not to follow that.
No, if you are right that you can always prepare a panel, there's no difficulty. If you say that, well, others, it's only optional, they're not bound by it, then of course that resolves their argument. Now take the flip side, what you said, and apropos what fell from Brother Narsima, you are suggesting this essentially for the public sector context. Take a case of a private insurance company, all right, who has insurance dealings with individuals. They put an arbitration clause in a.
I have answers. My lord, can I show the
Now,
scheme?
every private insurer, will they say that, well, we will prepare a panel which will be broad-based, our process will be transparent, we will invite people to apply for our panel. There'll be like 100 insurance companies, 100 construction companies,
I'll be able,
100 engineering companies. How would that preparation?
I'll
of
be
a
able
panel,
to show examples, my lord, where banks have similar systems working very effectively, which is called online dispute resolution. I'll be able to, my lord, let us, my lord, start with this one. I think I started from a wrong
No,
side
no,
of
not-
the.
No, no, we are not,
We are
we are not,
discussing,
we are not saying what
against
you are
you.
saying is, we are not against you.
No, I
We
understand.
are
These are,
just
my lord.
trying to explore the limits of your submission, please. I mean, we
No,
understand.
I
A
understand.
great deal
I'm
of, a great
conscious
deal
of.
of thought has gone on your part and your team into making these submissions. We respect that. We're not against you. We're just trying to explore the limits because when we write a judgment,
Lord,
eventually we'll have to factor that
Your
in.
lordships would also examine and, my lord, bind parties where one company enters into a contract with another company. The question will be, if one company says that we will have a broad-based panel out of which you will have to elect, would that pass the muster?
One minute.
Yes, yes.
Solicitor, invariably we are getting into areas of intersection of public law and private law.
Correct, my lord.
Where does public law come in? Even if it is a private contract between the parties, if there is a clause which is unconscionable, to that extent, in public law, we will set it aside. Therefore, that will come in the realm of public law proceedings. But if we go further and then say that clauses should be of this nature, clauses should be of level playing field, and start prescribing the method and manner by which private parties could compose the private remedies, then it has, the distinction is completely done away with. Only
I bow down.
Only that far and no further. All these arguments are in fact arguments in the realm of public law saying that you can't have a unilateral clause. So that should lead to, like in O'Reilly versus Macman, file a petition before a public law court and say this clause is invalid. You can't have a contract, section 28 of the Contract Act is actually invoked. So to that extent, the clauses could be set aside because if there
In
is
an
something
individual
relevant
case.
in the contract, that we will do, that remedy we can give.
In an individual case,
To administer a private,
it cannot be done. My lord, can I show, my lord, how the
So
private?
one more thing I would like to add. Ultimately, what jurisdiction will we be exercising? We'll be exercising the 142 jurisdiction of this court.
No, my lord,
Now,
my lord,
as
ignore
well,
that.
we have no such power. As a court, we have no such power. Now, exercising the 142 jurisdiction to lay down structural parameters for composition of arbitral tribunals, I dare say that, we'll be soundly criticized in the world of, business and,
It's something which I would, my lord.
what has the Supreme Court done? Because, so.
No, I'm not on that, my lord. I think we are completely on different.
versus Macman.
You see, the panel that you are proposing,
Because
No, forget the panel for the time
all
being.
right, I mean,
Let us park it.
but what has been suggested is it will definitely address the concern about impartiality, independence, integrity. But then it does not address the concern of party autonomy, which is very relevant in the realm
Yeah,
of
exactly, my
arbitration.
lord. There, I'm sorry. I'll show it from the act itself. Let me, my lord, now confine to the act. Now, my lord, as my lord Justice Narasimha has rightly said, that this is to be, the answer has to be found from the private law remedy of contract. Lord, please have a look at, my lord, the Arbitration Act. Let us see, my lord, what the act says. Now, forget, my lord, the government or public sector undertakings. Let us see, my lord. Lord, please come to chapter 2. Your lordships possibly are referring to the book, my lord, not the.
We can go to the soft copy.
No, I'm.
Where is the soft copy of
No,
the
no,
act?
I'm the better.
No, but-
This is better. This is better.
We're making sure that you also become completely digital.
No, my lord, I am using digital, my lord. I am using digital, but uh, for the act, my lord, I prefer the bare act. Now we are in a private domain. Lord, we are in a private domain, and kindly, my lord, keep two examples in mind, which are, my lord, for example, public sector undertaking. I am not obsessed with that while answering this question, but public sector undertaking having an apprehension that exclusive choice would result into a kind of not neutral or not impartial situation. Number two, kindly bear, my lord, these examples in mind. I'm not naming the company, but it is a part of a judgment of this honorable court, and I have filed an affidavit. I'm sorry, my lord, just
Yes, no.
is on something else.
Public sector
Yes.
company.
No, first is a public sector company, my lord, having no level playing field. They choose the arbitrators, particular arbitrators of their choice, and my lord, there is an apprehension that we usually end up, my lord, not having a level playing field. And I know your lordship knows what is the meaning of that expression. Second example, now in a private domain, there is one company of which I know, and it's a part of the judgment. It's a construction company of a big scale. They enter into contract only to ensure that the contract is eventually terminated midway, and they file arbitration and earn a big award. And I have filed an affidavit on behalf of the company that their main income is out of arbitral awards, not from the business. Now, I am a private company. I am Larsen and Tobro. I am JSW. I am entering into a contract with that company. I am saying that this is going to be my clause in the contract. You take it or leave it. It's a voluntary act. This is, my lord, second example. Please bear these two examples in mind and see how the scheme of the act operates. There is, in every section, every part, there is a party autonomy ingrained. It's not something, my lord, which a party which is insisting for a panel is doing for the first time or doing contrary to law. Lord, please have a look at section 4 now.
if you have a
contracts also between A company and B company. There are apprehensions that B company may have a better level playing field than A company in private contracts. But forget everything. Let us see, my lord, what the Act says. And whether,
let's read, we'll read the provision of the Act and see how you're reading.
yes, my lord.
let's
And
see.
whether if the Act does not prohibit, alternatively, if the Act permits one party to have a clause regarding there being a panel, which right now, my lord, there is doubt whether it is permissible or not.
So let us
Whether the
read-
Act permits.
we'll read
Please
the
come
Act.
to page section 4. Section 4. Section 4. I'll invite your lordship's attention to only relevant clauses, my lord, just to which assess the court, my lord, in this particular question. Section 4, your lordships have, my lord. I'll read. A party who knows I'm sorry, can I read, my lord, if your lordship? A party who knows that A, any provision of this part from which the parties may derogate, or any requirement under this under the arbitration agreement has not been complied with, and yet proceeds with the arbitration without stating his objection to such non-compliance without undue delay, or if a time limit is provided for stating that objection within that period, shall be deemed to have waived his right to so object. My lord, the meaning, as I have understood, is that party, if it is clear that some provision is derogable, but agrees to it, or there is some requirement in the arbitration agreement, but permits it to be waived, if I may use, my lord, my expression, then it is prevented, meaning thereby
the estoppel principle.
correct, my lords. Meaning thereby
The estoppel, because
estoppel, your lordships are right, no?
principle of estoppel not against a statute will not apply here. So estoppel will apply.
The statute operates as an estoppel. The statute says your conduct operates as an estoppel. We don't have to borrow the.
Now, what do you think are the derogable provisions?
Pardon?
Which are the derogable provisions?
I'll come to that, my lord. Kindly, my lord.
Just bear that in mind. Later on,
I know, my lord. I'll have to answer that, my lord. My learned friend has says 34. I have something to say on that, my lord.
all right,
And
then section 4, then what is?
Section 4. Lord, this says party autonomy. You can have a provision, and by conduct, you can waive that provision, and thereafter don't object because you are stopped from objecting. That is section 4. Now, please see, my lord, the title of chapter 3, and this is, my lord, relevant. The title of chapter 3, which is section 10 onwards, is composition of arbitral tribunal. Your lordships are
going back to 4. 4 is in two parts. The first part deals with derogable provisions of the Act.
Yes, my lord.
The second deals with the arbitration agreement.
Correct.
A requirement of the arbitration agreement.
Yes.
If you don't raise it at the earliest possible opportunity, you are stopped thereafter. You
I'll
can't
just
raise.
give an example what it means.
It's like the CPC says, objection as to place of suing or territorial jurisdiction. You don't raise a point of territorial jurisdiction at the earliest possible opportunity. You can't raise it later on.
Correct.
If it's otherwise a court of competent jurisdiction, you can't say that the suit was filed in Gurgaon instead of Delhi later.
Another example, my lord, what B means. My lord, your lordships have come across. Your lordships have come across several arbitration clauses. Generally, that arbitration will have to precede the conciliation, that there has to be a conciliation, and if it fails, then arbitration.
That's that clause B, requirement of the arbitration.
Exactly. So that suppose somebody straightway come to the arbitration, participates, then he cannot say that we have missed
No
once.
conciliation.
That's my lord, so this is party autonomy. Nothing turns on the question in hand, my lord. Now,
Like the
please-
MSME Act says, you must have conciliation and then arbitration.
Yes. No, even in several agreements,
Yeah.
there is a provision for conciliation first and then arbitration. Now, chapter 3, composition of the arbitral tribunal. This is the only chapter which provides how arbitral tribunal can be constituted. And as per the definition, sole arbitrator is also a tribunal, multi-member panel is also a tribunal. Now, my lord, 10 is not relevant, my lord, for either of us. Please come to 11. The way, my lord, I would respectfully read section 11. And if my learned friends are right, then we will make one provision at least nugatory. Provision in the chapter of composition of arbitral tribunal. And your lordships would also simultaneously find the party autonomy, a tailor-made, customized agreement is in contemplation of the parliament. Everywhere, my lord, in every section.
Procedure for arbitration.
Yes. Now, 11, my lord. A. 1. A person of any nationality may be an arbitrator unless otherwise agreed by the parties. Here comes party autonomy and the freedom to enter into a contract. This is relevant only to show that parties can agree. The contract is supreme. But second is most important question, important provision.
Procedure for appointing the arbiter.
Subject to subsection 6, the parties are free to agree on a procedure for appointing the arbitrator or arbitrators. There can be an agreement which says that procedure will be as conventionally followed. I will select my arbitrator, other side will select his arbitrator, and both will request for someone to preside over. That can be one procedure. Another procedure can be you voluntarily enter into a contract which provides for an arbitration agreement which says that the procedure of appointment will be a panel of arbitrators, and you select one from the panel. Correct, my lord? Nothing prevents up to subsection 2 from parties in their act of volition agreeing into an agreement about the procedure for appointment.
Yes.
Now, this interpretation of subsection 2 gets further strengthened by subsection 3. Failing any agreement referred to in subsection 2. So, procedure of your choice, party's choice. If you cannot arrive at or the arbitration agreement is silent, failing any agreement referred to in subsection 2, in an arbitration with 3 arbitrators, each party shall appoint 1 arbitrator, and the 2 appointed arbitrators shall appoint the 3rd arbitrator who shall act as the presiding arbitrator. So this is the second statutory option. First option is that you choose your method of constituting the
So
tribunal.
3 is an exception to 2.
To 2. So other than this conventional method of one electing one selecting one, another selecting second, and they selecting presiding arbitrator is an exception if there is no other customized mode of arbitration tribunal constitution is provided for.
If parties have provided for a procedure for appointment,
Yes, my lord.
then that will govern.
That will govern.
So that shows that that procedure for appointment is a derogable provision. Isn't it?
Yes.
Subject to, it's a derogable provision. The very fact he says that it's failing an agreement,
Correct.
show that
It's that-
once there's an agreement, that agreement prevails.
Yes. Not even one is derogable. That arbitrator can be,
Even a sole arbitrator.
yes, arbitrator can be of any nationality, is also derogable. That unless parties otherwise decide.
The only non-derogable provision is it shall not be an even number.
Yes, it can't be. It can't be. Then, my lord, 3A. The Supreme Court and the High Court shall have the power to designate arbitral institutions from time to time, which have been graded by the Council under Section 43(1) I for the purpose of act. My lord, I'm skipping the proviso. Please come to 4. Subsection 4. This may not assist your lordships. 3A will have no relevance for this question. Your lordships are on subsection 4, my lord?
Yes, 4.
4. If the appointment procedure in subsection 3 applies, meaning thereby no agreement. Subsection 3 is in absence of customized agreement. Then what? And if there is no such provision, 3 applies, then a party fails to appoint an arbitrator within 30 days from the receipt of a request to do so from the other party, or the 2 appointed arbitrators fail to agree on the 3rd arbitrator within 30 days from the date of their appointment, the appointment shall be made on an application of the party by the arbitral institution designated by the Supreme Court in case of international commercial arbitration, or by the High Court in case of arbitrations other than international commercial arbitration, as the case may be. So if there is no customized, I'm using that expression, agreement, then 3. If 3 is also not present, then 4. Then kindly come to 5. Failing any agreement referred to in subsection 2. Your lordship has that, my lord. So there is no provision for a customized manner of constitution. In an app,
Just 4 or 5 minutes.
yes, my lord, your lordship may come after 10 minutes.
5 minutes.
Have some
Just
rest.
5 minutes. Just to stretch it. That's all. Yes, Mr. Adam.
Wait, please. Lord, I was on subsection 5.
Yes.
Lord, your lordships would mark one thing, that 4 comes into play when 2 is absent. I hope, my lord, I am
Right, right.
correct, my lord. 4 comes into play when 2 is absent. 2 is absent when there is no agreement between the parties providing for the procedure.
Yes.
Now, that is first 4 when there is no agreement, then 5, subsection 5. Lord, 5. Yeah,
Yes.
I'm sorry. May I read 5?
Yes.
5. Failing any agreement referred to in subsection 2. So, no procedure prescribed. In an arbitration with a sole arbitrator, if the parties fail to agree on the arbitrator within 30 days from the receipt of a request by one party from the other party to so agree, the appointment shall be made on an application of the party in accordance with the provisions contained in subsection 4. The highlight, my lord, which I would respectfully make is that 4 and 5 would come into picture only when there is no procedure under subsection 2. Justice Narasimha, my lord, I am able to make 4 and 5 will come only when there is no 2.
Yes.
Now, 6. Where under an appointment procedure agreed upon by the parties, that is under subsection 2, a party fails to act as required under that procedure, or the parties or the 2 appointed arbitrators fail to reach an agreement expected of them under that procedure, or a person, including an institution, fails to perform any function entrusted to him or it under that procedure. My lord, the procedure may stipulate. Just giving a hypothetical example, that in case of a dispute resulting into an arbitration, the arbitral tribunal would be constituted, say, by Delhi Arbitration Center. That can be, my lord, a possible, which is considered, my lord, under 6C. The appointment shall be made on an application of the party by the arbitral institution designated by the Supreme Court in case of international commercial arbitration, or by the High Court in case of arbitrations other than international commercial arbitration, as the case may be, to take necessary measure unless the agreement on the appointment procedure provides other means for securing the appointment. I'm sorry, my lords.
Yes.
Even 6 is derogable. Please see, my lord, 6, last line. If either of these 3 contingencies arise, namely parties do not appoint, party appointed arbitrators do not appoint a presiding arbitrator, or if an institution is named in the agreement, the institution does not do anything, then the party will approach the High Court or the Supreme Court, but that is subject to last unless the agreement on the appointment procedure provides other means for securing the appointment. So even approaching the Supreme Court or the High Court is also a derogable provision by agreeing to it under an agreement made under 2. Lord, now, Lord, omit 7, it is omitted in 2019. Kindly come to 8. Your Lordship has 8.
Yes.
The arbitral institution referred to in subsection 4, 5, and 6. Lord, 6, provided there is no contrary agreement. But let us take that there is an agreement. And either 4 or 5 or 6, the institution which your Lordships have designated is approached. Before appointing an arbitrator shall seek a declaration, disclosure in writing from the prospective arbitrator in terms of subsection 1 of section 12 and have due regard to. Kindly pause here for a minute. The argument of Mr. Banerjee was that this part is non-derogable. I agree to that. I have a customized agreement under subsection 2. There is a failure and 4, 5 or 6 kicks in. 6 will kick in only, my lord, in case of 2. Correct, my lord? Am I clear? Subsection 6 will kick only when there is an agreement under subsection 2. But then 12 is non-derogable. You cannot appoint a disqualified person who is disqualified under section 12. I'll come to that, my lord. So, my lord, again reading, the arbitral institution referred to in subsection 4, 5 and 6. If we have 2, we are not concerned with 4 and 5. Before appointing an arbitrator shall seek a disclosure in writing from the prospective arbitrator in terms of subsection 1 of section 12 and have due regard to any qualifications required for the arbitrator by agreement of the parties and the contents of the disclosure and other considerations as are likely to secure the appointment of an independent and impartial arbitrator. But we are not concerned with A and B because their argument was that 8 is non-derogable, to which I have no difficulty. My right under subsection 2, my volition and their volition to enter into a contract with a customized arbitration procedure, customized procedure for appointment of arbitrator will be not bound by section 12. I cannot disqualify anyone. I cannot make my manager an arbitral. But giving an example, how 8 operates. There cannot be an agreement under subsection 2 which says that my managing director will be the arbitrator because that is prohibited under 12. 12 mandate will apply to my choice and their choice in entering into a contract under subsection 2. Now please come to 12, section 12. My lord, rest will not assist your lordships either way. And my lord, whatever I am skipping, your lordships can take it, is not relevant for either of us. My lord, in such matters, we don't argue, my lord, to win a case or lose a case. My lord, we really assist the court. Seven. Lord, there are some provisions which came in 19, my learned friend Lord points out.
In fact, I was comparing it with your soft copy and then the hard copy because these are the post-19 provisions.
So you relied.
The institutional part of it is not.
Lord, it does not make any difference to the interpretation. I think he agrees. Are you agreeing or not?
I'm saying that this section is technically not the correct provision.
So the correct provision of 8 is in footnote 2.
Correct. It is the Chief Justice, the High Court or the Supreme Court.
Yes,
Chief Justice or the person or institution designated by him in appointing an arbitrator shall have due regard to any qualifications required of the arbitrator by the agreement of parties and any other considerations are likely to secure the appointment of an independent and impartial arbitrator.
My lord, the sum and substance of what my learned friend says, and I agree, is instead of institution, please read the Honorable Chief Justice. That's all, my lord. Nothing turns on the interpretation or the issue we are confronted with. Now, please come to, my lord, section 12. I'm sorry, my lord. My lord, the Chief Justice is somewhere, my lord, in some.
Of subsection 8 says other considerations
Yes.
as are likely to secure the appointment of an independent and impartial arbitrator.
When?
Therefore, the court has that duty to ensure that the person you are appointing is independent and impartial.
Yes. Correct, my lord. But that is even in abs. That's what I'm saying. Lords, only at the cost of repetition, let me say, Lord, even without this provision, the court has the duty to appoint an impartial and independent arbitrator. Nobody disputes that. But Lord, at the cost of repetition, Lord, please note this. 8 kicks in when 4, 5, 6 is present. And 4, 5, 6, 4 means no agreement under 2. 5 means no agreement under 2. 6 means there is an agreement, but you fail to act. So this does not touch upon the party's autonomy to enter into a contract providing for a specialized mechanism for appointment of arbitrator.
No, but even where the parties have provided for a procedure
Yes,
for the appointment of an arbitrator under 2,
correct.
thereafter, if you look at the provision prior to 2019,
Yes, Madam.
it says 6.
Lord,
Where
6.
that 6 prior to the amendment,
Yes, Madam.
where under an appointment procedure agreed upon by the parties. So we are now dealing with an agreed procedure.
Yes, but 6 is for that, Madam.
Right. A party fails to act as required under that procedure. Or the
Correct.
parties or the 2 arbitrators fail to reach an agreement expected of them.
Correct.
Or a person, including an institution, fails to perform. Party may request the Supreme Court, or as the case may be the High Court or any person or institution to take the necessary measure, unless you pointed out, unless the agreement on the appointment procedure provides other means other than going to the Supreme Court or the High Court or the institution.
Correct.
All right. Now, when 8 says,
Before that,
Yes.
my lord, kindly pause here for a minute on my request. My lord, 6 definitely would kick in. 6 necessarily presuppose an agreement under 2
under 2,
and non-compliance of what is stipulated under that agreement.
right?
Correct, my lord. Now kindly come to 8. The arbitral institution referred to in subsection.
Just read 8 from the soft copy, actually.
Yes.
Which is at 111.
Yes, sir. Where 8, your lordship.
8. The Supreme Court.
The Supreme Court, or as the case may be the High Court, or the person or institution designated by such court, before appointing an arbitrator, shall seek a disclosure in writing from the prospective arbitrator in terms of subsection 1 and 1 of section 12, and have due regard to A, any qualifications required for the arbitrator for the agreement of the parties. So your lordships, your lordship means the Supreme Court or the High Court will also be governed by the agreement under 2.
And B says the contents of the disclosure, and so the disclosure has to be made before you appoint the arbitrator.
Correct.
And other considerations, that's very important, and other considerations as are likely to secure the appointment of an independent and impartial arbitrator.
Correct, my lord.
This seems to suggest that even where parties have agreed to the procedure for the appointment of an arbitrator, but that procedure has not been implemented for a variety of reasons, you move to Supreme Court. Supreme Court is not bound, or the High Court is not bound by that procedure. That's the point.
No, no, my lord.
There are a line of 3 judgments of Justice Lodha where under the agreement, there is an obligation to appoint an arbitrator, but one of the parties has not complied, so 11.6 come into the play. It was argued at that stage that now 11.6 has been filed, but when a court appoints, you must appoint according to the arbitration agreement. He has rejected that argument, saying, number one, that freedom no more exists because of non-compliance of you. Now the power and right exclusively rests in the court itself, and we will appoint. And when the court appoints, the procedure contemplated under 8A and B will apply. Those are the line of cases.
In case of non-compliance, we are concerned.
Right, obviously.
The issue arises only on non-compliance.
We are concerned whether two can have a particular procedure or not.
Of course, two can have a procedure.
But, my lord,
But
can
if
we
that
read it again?
procedure has failed and the matter comes to the court, then you are not bound by the rigors of the procedure which have been provided by the
Certainly.
parties.
Well, certainly, but please read 8 again.
Because when the court appoints, there's an overarching duty of the court to protect independence and impartiality. And therefore, the court is not merely a rubber stamp to say, okay, I'll look at the agreement and I'll appoint the same person or the same people, however lack of independence or impartiality there may be.
No, that's not my argument also. I'm not, my lord, pitching it that high, but please read it again. 8. My lord, what would be your lordship's consideration, the Supreme Court or the High Court's consideration? The Supreme Court, or as the case may be, High Court, or the person or institution designated by such court before appointing an arbitrator shall seek a disclosure in writing from the prospective arbitrator in terms of subsection 1 of section 12 and have due regard to. So this is disqualification disclosure and due regard to. A. Any qualifications required for the arbitrator by the agreement of the parties. Suppose, my lord, agreement of the party says a chief engineer will be appointed. Then your lordships will have a regard to that.
That's because earlier set of cases said that even if court appoints, it must go by the agreement.
Yes.
That
is
got
1940
after
Act.
the amendment and the 2 judgments also.
Yes, 1940 Act. Those. Then, and second, the contents of the disclosure. My lord, disclosure means, I'll come to
by the prospective arbitrator.
12, the disqualification. The contents of the disclosure and other considerations, which is, my lord, a wider, completely wide room, my lord, for the court, my lord. So apart from disclosure, your lordships can likely to, will appoint a person who is likely to be independent and impartial. So, my lord, sum and substance is, there can be an agreement under 2, complete autonomy. If there is an agreement, but conditions not complied with, you come to 6. While exercising powers under 6, your lordships will examine 8.
But if there is no failure of the procedure, then parties are bound by what is envisaged in that procedure under 2.
And therefore, 2, yes, brother, 2 does not prohibit parties to agree to a particular procedure which may include a procedure of selection from the panel.
Invariably, 11 is filed on the ground that I've asked for arbitration, but they are appointing from the panel. So 11.6 is filed on that ground.
No, but they cannot, if they have agreed under.
Cannot, it's your argument.
That's my submission. Yes, yes. Your lordships are right. So long as 12 is met. So now kindly come to section 12. Section 12 again is housed in the chapter titled Constitution of the Tribunal, Composition of the Tribunal. Am I with your lordships on section 12?
Yes.
When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any of the circumstances. My lord, he shall. This is non-derogable.
Yes.
So he must disclose, my lord, either approached by the party as per the procedure prescribed under section 11(2) or maybe by the Supreme Court or the High Court. A, such as the existence either direct or indirect of any past or present relationship with or interest in any of the parties or in relation to the subject matter in dispute, whether financial, business, professional, or other kind, which is likely to give rise to justifiable doubts as to his independence and impartiality. Kindly see, my lord, the clauses, because this does not disqualify him. The only, my lord, responsibility is to disclose. Then B. And B, my lord, I have a separate submission to make, my lord, for your lordship's kind consideration, which are likely to affect his ability to devote sufficient time to the arbitration, and in particular his ability to complete the entire arbitration within a period of 12 months. This is what a prospective arbitrator is supposed to give. My lord, I'll come to that point. I'm not raising it right now, my lord, but this is a very, very vital point, my lord, which will go to the root of the issue. Then explanation 1. The grounds stated in the 5th schedule my lord, in ICC arbitrations, when an arbitrator is appointed, I'll show, my lord, when I come to that. Sorry. ICC arbitrations, prospective is approached. My lord, in ICC, my lord, I'm not, my lord, I'm not arguing this right now. At the end, I'll say, but just as a by way of an information, in ICC arbitration, whenever a prospective arbitrator is approached, he is requested, there is a format that give me your calendar of 24 months henceforth. They decide whether he is able to devote sufficient time and whether the arbitrator would be able to complete it within a time period. I'll come to that, my lord, but that a little later. Now, my lord, 2. An arbitrator, subsection 2, from the time of his appointment and throughout the arbitral proceedings, shall, without delay, disclose to the parties in writing any circumstances referred to in subsection 1, unless they have already been informed of by him. Suppose some disqualification, not disqualification, some contingency under 12(1)(a) occurs during the arbitration. So he is supposed to disclose that. So throughout the liability of disclosure continues. Now 3, an arbitrator may be challenged only if A, circumstances exist that give rise to justifiable doubts as to his independence or impartiality. Kindly pause it here pause here for a moment. Lord, this is one of the grounds on which his appointment can be challenged. And if your lordships can now read it with explanation 1, appended to, my lord, immediately after B, subsection B. The grounds stated in fifth schedule shall guide in determining whether circumstances exist which give rise to justifiable doubts as to the independence or impartiality. So this is to be connected with or read with 3A. 5A grounds are generally the guiding principles, but they are not, my lord, the exhaustive list. There can be other, my lord. One of my learned friends said that there is one arbitrator in the panel who always decides in favor of one party. Maybe that can be a ground, my lord, under 3A. That we have a reasonable ground that he is not neutral, he is not impartial, he is not independent. Then B, he does not possess the qualifications agreed to by the parties. Then 4, a party may challenge an arbitrator appointed by him or in whose appointment he has participated only for the reasons of which he becomes aware after the appointment has been made. If he is already aware when the appointment was made, then waive. It is derogable. Then he cannot challenge, a stopper. You cannot challenge. Then 5. 5 is, my lord, non-derogable. Please see, your lordships have seen 12.1, mere disclosure, no consequence. Now 5, notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in the 7th schedule shall be ineligible to be appointed as an arbitrator. This is the distinction between 1 and 5.
Yes.
So 1 is mere disclosure, 5 disqualification, he is ineligible. Lord, this will govern 11.2 also. There cannot be an arbitration clause which permits a person falling under 12.5 to become the arbitrator. That is non-derogable.
So Schedule 5 can be derogated from. Parties may say that, well, despite the fact that there may be justifiable doubts as to his impartiality and fairness, I still accept him. So,
I
but
will tell him-
7 schedule is ineligibility.
Yes,
Exactly.
I understand, but if I agree to 7, I necessarily agree to everything which is in 5
What
akin to 7.
family arbitrator, suppose you
There's a waiver, my lord. Family arbitrator, there's a waiver under 12.5 proviso. You can
12.5
waive, you can waive
Waive
it
afterward.
after. You can waive
after
it.
disputes have been carried.
And that's what the law commission says in paragraph 60, that in family arbitrations, you can waive it. That was one of the examples.
Right.
Yes, because it's always advisable that someone related is the arbitrator. No, please see the proviso.
This waiver under 12.5 proviso,
Yes,
it is subsequent to dispute. having
Subsequent,
been
yes,
They can
yes,
do that
yes,
at
yes.
that stage.
it cannot be at 11.2
It
stage.
not be at the stage.
And it has to
beginning.
be,
An express agreement in
and
writing.
it has to be an express agreement. in writing.
Express agreement. Yes.
I know that the arbitrator is my uncle, but we both agree to his arbitration.
Well, therefore, we are not concerned with such a scenario, but absent the proviso and the agreement contemplated, even in family arbitration, 7 would kick in. So, provided that parties may, subsequent to the dispute having arisen between them, waive the applicability of this subsection by an express agreement in writing. So this is not, this is to be contrasted with other provisions where you can, by conduct, condone ineligibility or disqualification.
Is there any other provision which uses this expression, notwithstanding any prior agreement? Because this is the only provision, I think, which overrides an agreement.
This is subject to correction, but other provisions are subject to the agreement to the contrary.
Yes, it's the converse. So therefore,
This is
shows
notwithstanding,
importance.
more rigorous. Otherwise, possibly, the effect is same.
There's some commentary which I showed yesterday, which said that that list was not drawn up because you could make out wherever it is subject to the contrary, it is not mandatory, and where it is not, it is.
No, that's my comment. I have something, I have some reservation. Commentaries, are ultimately views, but notwithstanding anything to the contrary, or at the end, subject to the contrary agreement, would have the same impact. But notwithstanding anything contrary to the agreement means the statute provides prevails. Correct, Manoj? But statute is exempted by the provision by saying that except where parties agree otherwise. So they are converse situations. Yes. Now, Manoj, please see.
Section 5 provides for non-derogability in its substantive part, but that is relaxed by the proviso where there is an express agreement between the parties after the dispute has arisen.
Yes, Manoj.
Why after the dispute has arisen? Because parties are conscious of what is the nature of the contentious matter.
And the nature of this.
Understanding the contentious matter, they expressly agree in writing.
That my maternal uncle would
This
arbitrate.
person
Although he may be otherwise related, qualified.
cannot be upfront before the dispute has arisen. You must be conscious of the dispute and then expressly agree it in writing.
And this is just, Manoj,
The exception.
academically for interpretation. Some of the provisions say that by conduct, you are deemed to have waived your objection. This is the provision where for 7th schedule, there has to be an express agreement, not merely by conduct or by inaction. By not objecting, you cannot waive. There has to be an express provision.
So and the overriding of a prior agreement by subsection 5 is subject to the further exception carved out in the proviso.
Correct. Now, my lord, kindly see 14(1)(b). I'm just, my lord, saying that everything is party autonomy. You can contract whatever you want to contract. Because instead of a conventional litigation method, you are devising your own method of adjudication. Therefore, the entire act is replete with party autonomy, that you decide whatever you want to decide. Just as an example, 14(1)(b), the mandate of an arbitrator shall terminate and he shall be substituted if he withdraws from his office or the parties agree to the termination of his mandate. Parties can even enter into an agreement which says that now henceforth we are in the middle of arbitration, but we terminate your mandate. Everything is party autonomy driven. Then, my lord, please see next chapter, jurisdiction of tribunals. We are not concerned. I'm just, my lord, highlighting the my lord, heading of the chapter. 16 is competence of arbitral tribunal to rule on its jurisdiction, and 17 is, my lord, interim measures. My lord, we are not supposed to read it. Now, please come to chapter 5. Now, thus far, your lordships were examining sections under the heading composition of the tribunal, with which we are concerned. To whom? By दोनों side of me.
We will finish by 1 o'clock.
My lord, yeah, Lordships would agree on 2 points. We started little late. I started, my lord, further late, my lord, I was answering. And this happens, my lord, when you are on the, to come to bat, my lord, after the first inning. And, my lord, I have not been repetitive or irrelevant, my lord.
Roughly how long?
Not more than, my lord, half an hour.
Try and sort of compress it as much as you can within half an hour.
I'll try.
We are trying to lay down.
Yes, my lord, please come to, my lord, chapter, I'm sorry.
You have been highlighting the principle of party autonomy which runs through the entirety of the act. That's what you're saying.
Yes, and Lord, I'm also dealing with their submissions, my lord, which are made in my respectful submission out of context. That's what, my lord, I'm trying to show by saying that one chapter, composition of tribunal, is over. Now, my lord, chapter 5, conduct of arbitral proceedings. So the tribunal is constituted, whether it's a sole arbitrator or a multi-member tribunal. Now, how the conduct will take place, please come to 18, my lords. Section 18. Equal treatment of parties, your lordship, say, my lord. My lord, say, my lord.
Yes.
Equal treatment of parties. The parties shall be treated with equality. By whom? By the arbitrator. Because it is in the chapter of conduct of arbitral proceedings. And it next line, my lord, strengthens the interpretation, my lord, I am respectfully giving. The parties shall be treated with equality and each party shall be given full opportunity to present his case. By whom? By the arbitrator. This does not talk of equality in terms of the contract under 11.2. This is before the arbitrator. The tribunal is constituted and now proceedings are going on.
Here, the argument of the other side was that the conduct of the arbitral proceeding would also include the appointment and composition of the arbitral proceeding, the arbitral panel.
Yes, sir. I'm
And that is the,
mindful of that.
I'm sure that you are trying to address that,
Yes.
which was argued yesterday.
Yes, sir. Because composition is a separate chapter providing for every step of composition. Conduct has a separate chapter providing for every step in conduct. And unless, my lord, we give that meaning, my lord, how would we reconcile 18? The party shall be treated with equality. By whom? By the arbitrator, and it gets strengthened, and each party shall be given a full opportunity to present his case. By whom? Obviously, during the conduct of arbitral proceedings by the arbitrator.
Followed by 19, which lays down the.
So this equality is not equality of entering into an agreement under 11.2.
This is the manner we also read it,
Yes.
as we read yesterday, because it is immediately followed by 19, which talks about the procedure. And that will be governed by the arbitral. But the argument is that no, even at the stage of appointment, this equality principle should come.
Not treated equally by whom? We are two parties. We can't treat each other equally. We can contract that one will not be equal to the other. It's an act of volition. It's purely in a private domain, private law. When it says giving an opportunity of hearing, my lord, would we give opportunity of hearing to each other? When it is, my lord, under the heading conduct of arbitral proceeding with a mandate that everyone will be heard, means by the tribunal. There cannot be, my lord, with profound respect, any other meaning given to it. To come out of this argument, my lord, the reliance is placed on 21. Now, please come to 21. Unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commences on the date on which a request for that dispute to be referred to arbitration is received by the respondent. The argument is that it is only after this notice, arbitration notice, that the tribunal is constituted. And therefore,
Yes.
18 should be read as
Commencement.
commencement. Lord, why this section 21 is placed in this chapter? Not to ensure that the entire chapter applies to the initial appointment of initial contract, which would determine the method of appointment of arbitrator. Please come to Malot 23. Within a period of time agreed upon by the parties or determined by the arbitral tribunal, the claimant shall state the facts when the claim will be made. Malot, there has to be a beginning of time, my lord, when the proceedings continue, proceedings start, that from the date of the notice, within 5 months, you must file your statement of claims because the object of the act is expeditious disposal. 21 is in this chapter only to ensure that parties can use that date as a starting date for filing statement of claim, filing defense, filing documents, etc., etc.
Earlier, under 40 Act, commencement was declared to be from the time when an arbitrator enters reference.
Correct, my lords.
That they have deliberately changed it to.
Yes, my lord. But my lord, even 21, my lord, please come to 21 again. I'm obliged, my lords. But please come to 21 again, my lord, on my request. Unless otherwise agreed by the parties.
It's a derogable provision.
Yes, so we can say that the date of commencement would be the first meeting of the arbitral tribunal. This is why it is housed in the chapter which provides for conduct of arbitral proceedings. Lord, one more I missed, my lord. I'm obliged to my learned friend.
Procedure will be subject to.
Lord, I'm obliged to my learned friends. My lord, I missed section 19, which furthers my, my lord, respectful interpretation of 18. Please see, my lord, 19. The arbitral tribunal shall not be bound by the Code of Civil Procedure or the Indian Evidence Act. Subject to this part, the parties are free to agree on the procedure to be followed by the arbitral tribunal in conducting the proceedings. Failing any agreement referred to in subsection 2, the arbitral tribunal may, subject to this part, conduct the proceedings in the manner it considers appropriate. So 18 is during the conduct of arbitral proceedings. And 19 presupposes that there already a arbitral tribunal in existence. It is constituted under Chapter 2. Now, my lord, please see the first line.
Would stretched to its logical conclusion mean that the requirement of equality under section 18 would override even an agreed procedure.
Agreed procedure, and my lord, it would make the second part of 18 redundant, that parties will be given full opportunity of hearing. By whom?
Yeah, okay.
It can't be by each other, that I will hear him and he will hear me.
The relationship is governed by agreement,
11
but the conduct of arbitrator must be equal.
equal.
If it doesn't, then 34 comes in saying that you would not. And it is,
Suppose, my lord, there is an arbitral agreement that they would not have a right of defense except on ABCD grounds. Then 18 kicks in. Then the tribunal is bound to treat both equally and give them full opportunity. Suppose there is an agreement that they will not be heard. So 21 is housed in this chapter 5 because there is a provision for fast track arbitration agreement also. Parties can agree that now this would be the date. Date would be hypothetically the first meeting of the arbitral tribunal, and we agree that it would be over within 3 months. We put it on a fast track. Or this would be the date on which the arbitration has started, and we agree that within 1 month pleadings will be completed. Therefore, to smoothen the conduct of arbitration proceedings, 21 is kept here. But just quickly, 25, just first line, just to show, my lord, party autonomy is, my lord, writ large. It runs through the architecture of this act. Default of a party, unless otherwise agreed by the parties, this can be done. Then 26, unless otherwise agreed by the parties, the tribunal may appoint so and so. So parties are free to choose what they are contracting, what is their commercial bargain. Now, Lord, sometimes your lordships do something to achieve the ends of justice in a 226 jurisdiction, which arbitral tribunal also can be conferred with. Please come to section 28, subsection 2. This also is dependent upon the parties agreeing to confer their jurisdiction. The title is Rules Applicable to Substance of Dispute, but relevant, my lord, is 2, subsection 2. The arbitral tribunal shall decide ex equo et bono or amiable compositure only if the parties have expressly authorized it to do so. Otherwise, arbitral tribunal is bound by the terms of the contract. Now, your lordships, my lord, kindly come to 34. May I continue, my lord?
We'll come back after. So we'll ask. Try. Lunch, we will, after the solicitor concludes, in the list which is given to us, we'll first hear counsel appearing for the parties. Then whatever time we are left, we'll give a little time to, the interveners. So we have Mr. Natraj for core, Mr. Arvind Kamath for BMRCL. Then we have Guru in Sundaram Finance, Ms. Madhvi Diwan for Mahindra Mahindra. Then we have Anand Padmanabhan for the petitioner in Equitas. And we have Suman Doval for the respondent in Nilcon. We'll give a little time to each one. And then whatever time remains, we'll ration out between the interveners and wrap it up today in the afternoon. All right, 10 minutes, one counsel on your side. All right. Now 10.
This is not derogable. Time is non-derogable.
I'm appearing for Tata Motor Finance. My application is filed.